Jack Smith now wants juror protection. This is also in the January 6th case. We're asking ourselves, what kind of protection do January 6th jurors need? They're Washington, D.C. jurors. Do they need protection from being mugged when they're out at their cars? Or do they need protection from Donald Trump's mean truths? Well, you know where Jack Smith is taking this one. And this comes on the Judge Chutkan docket. We'll take a look at what's inside because they're changing the rules. They know they've got a very favorable court and they're trying to modify the field so that they can win the game. And here is what they submitted. Now, this one is United States of America versus Donald Trump. This is the government's, again, opposed motion. So they've already talked to Trump about this. He says, I don't want you to go forward with this. I oppose. I object. This one from Jack Smith's office was written by Molly Gaston, the highlighter girl, the one who doesn't want Trump to read anything because she says, I organize it for you. She's writing this one. And what's interesting about how they titled these is this is their motion for fair and protective jury procedures, which, as you know, means that these will be unfair and that these will likely be protective for the government, not the process or the jurors. They write, trial in this matter in which Donald Trump, a former president, is charged with attempting to overturn the presidential election and disenfranchise millions of Americans and obstruct the peaceful transfer of power. Oh, this is definitely a Molly motion. I can feel it already. Is a matter of national importance and will likely generate significant public attention. Well, of course, that's why you guys brought the case in an election season after he's already announced that he's running, and why you scheduled trial the day before Super Tuesday. Like, that's the point, right? You want to prosecute him and criminalize him, but you don't want him to speak out in his own defense. So they say, Molly, to ensure that jury selection, voir dire, in this case proceeds in an orderly, efficient, and fair manner. And every time they say fair, you know it's unfair. What they're proposing. The government proposes that the court use a written juror questionnaire shortly in advance of in-person jury selection. A questionnaire, and we'll see if Trump agrees with this or not. A questionnaire would save time by allowing the court to excuse some potential jurors without requiring them to appear in court. By permitting the court to organize and streamline their questions, we can dispose of certain people. The questionnaire will only be given early access to prospective jurors, and we can conduct open source research regarding them. So the jurors will fill out the form, then we can investigate them. The court should impose reasonable boundaries for research, and Trump opposes the motion. All right, so Trump doesn't want any part of this. So here's what they say. Your Honor, the court, you, Judge Chutkan, you have broad discretion to manage jury selection. One of the things you do is maintain control of the process, preserve fairness, and the court's discretion includes determining whether we could use written juror questionnaires. It's one of the things that you can do. You can also do other things. You can pose questions, you can talk about anonymity of the jurors, you can sequester the jurors, and so on. In this case, Judge Chutkan, the court should exercise its discretion to streamline jury selection through the use of a questionnaire, and Trump's people say no. At the same time, in light of the public attention that is expected, and the defendant's record, Trump, of using public social media platforms in an intimidating manner, further evinced by the events in a separate trial in New York, okay, Trump was very vocal, the court should implement several of the standard measures frequently used, again, in this district to protect the jury, and impose additional clear guidelines about the use of information about potential jurors. They continue. The use of a written questionnaire will expedite the process of picking a fair jury. When confronted with trials that last a long time, they're going to require a large jury pool. And we've used other questionnaires in other partisan hack prosecutions that you've seen in this courtroom, including against the Oath Keepers and the Proud Boys. We used them in both their cases. Here, a questionnaire in this political prosecution will also make in-person voir dire more efficient. It's going to allow the parties to confer and strike jurors. It's also going to assist the parties in creating succinct lists of questions and save time. In particular, the government proposes the following schedule consistent with the written questionnaire process directed by this court. First, the court should order the government to draft a questionnaire, get with the defense, fill out a proposed questionnaire, and then the court can finalize it. So get with the defense and draft it. Then the judge will ultimately approve it. Then we'll send it out to the jurors. Depends how long, doesn't really matter. Days, weeks, months, doesn't matter. We send it out to them, and then they'll fill it out and send it back. If the court approves this use of the questionnaire, the parties will then learn the identities of the jurors in advance of jury selection. It's commonplace in this district for the parties, once they get the juror names to open source use social media to do research on them. And given the sensitivities of this case, stemming from Trump's record of using social media to attack others, the court should impose certain limited restrictions on the abilities of parties to conduct research on the jurors. Oh, so they don't want Trump to go investigate the jurors. Where is this going to go? They say that limited restrictions on the ability of Trump to conduct research on potential jurors. The court should also strictly enforce this district's rules to shield juror identities. They say it's pretty standard for people to do open source research on jurors. They look up their social media accounts and so on. And the court should make clear to the parties, though, like scold Trump, that research beyond what is publicly available, especially if it results in any kind of contact with a juror, would infringe on the juror's privacy rights. The parties should thus be precluded during jury selection from asking to follow or to friend anyone or to make any analogous affirmative requests. So Trump shouldn't be able to go and be friend request you to gain access to posts or profiles or other things. This prohibition should not apply to mere passive viewing of publicly available information. So you can view stuff but don't like it and things. And also the party should be precluded from any form of investigation, whether online or otherwise, that could be perceived as vexatious or harassing, which they're never intending to do anyways. So this is just kind of like smearing the defense, right? It's just like throwing crap at the defense. And it's really pretty rude and gross, but it's what they do. Like on the other end of this, they might think that it's insulting. They might think that Trump is, a Hitler reincarnate or whatever, right? They are literally that demented. But the lawyers, why would the lawyers engage in harassing investigations or inquiries? It's insulting to the lawyers. They're not going to do that, obviously. So the court should also prohibit the use of information gained from juror research from any other purpose other than jury selection. And even there, the court should require that if a party intends to use any information that they got, the party does so in a way that does not reveal any juror's identity. This limitation is consistent with local practice and so on. And they say, finally, the court should admonish the parties to handle juror questionnaires and jury sheets with care. Okay, admonish them, yeah. Hey, you guys and Jack Smith's office, you guys are constantly leaking to the media. A lot of the news comes from the Washington Post and the New York Times, including requiring each party to ensure that any individual who accesses these materials cannot publicly disclose the info. So with respect to the questionnaires, this is analogous to other restrictions that have been in place, and these precaution is not only necessary to ensure that all this information is handled appropriately, but also to ensure the court protects their identities. Now, here's where they get into Trump's statements. They say, Your Honor, Judge Chutkan, there are other good reasons in this case for the court to impose restrictions and enforce the prohibition against publicizing jurors' identities. Chief among them is Donald Trump's use of social media as a weapon of intimidation in court proceedings. Trump's posts are weapons of intimidation now. In addition to the record before the court from the government's previous filings, just last week alone, Donald Trump was in court in New York and escalated his conduct, and he publicly attacked the trial judge's law clerk in his pending civil fraud trial in New York. Trump did so by reposting on his Truth Social account, it's got 6.4 million followers, a photograph of the judge and the law clerk and a U.S. senator. He said, Senator's girlfriend is running the case against me. How disgraceful. So it was the judge Engeron. It was his clerk, and it was a picture with Chuck Schumer. And I think he deleted that post. He said this case should be dismissed immediately. As a result, the judge in that case was forced to issue an oral order that no party speaks publicly about the members of the court staff. And given that Trump, after apparently reviewing opposition research on the court staff, chose to use social media, there's a cause for concern he may do that with jurors too. So it's necessary that the court limit him on the research. Every time Trump posts something, they're going to try to finagle that in, right? Trump wasn't talking about jurors. Trump was talking about a clerk who was whispering in the judge's ear every time. Even before Trump's most recent concerning conduct, as the court is aware, Trump supporters had already directed threats to the court and to grand jurors who returned an indictment in Georgia. And they keep claiming that, but I don't believe it and I don't condone it. For these and related reasons, another federal court presiding over a civil case also involving Trump found it appropriate to adopt juror privacy requirements. So the court should do the same thing here to stop the jurors from intimidation and fear from Trump. And finally, jurors in this case are likely to receive substantial media. In consultation with the Marshal Service, we want jurors to get access through discreet arrangements to make it into the courthouse. That's why we request additional protective measures. In conclusion, Molly writes, to ensure ensure an efficient process for a fair and impartial jury in this case, the court should use a written questionnaire and adopt measures to protect the identities, privacy, and security of the jurors. Now, on its face, seems like a pretty bland motion, and we'll see what Trump's response says. Now, he's obviously opposing this, and we'll see if it's in substance or if it's in procedure, what the actual objection will be. I think obviously they're framing him as though he's intending to go do those things, and he's clearly not. And I think that if they agree to the motion, like obviously Trump is not going to go harass the jurors, okay? That's obviously not going to happen. And Trump's research, right? We didn't see anything in here that's going to limit his research other than he can't use it publicly. But I think we're going to see pretty hard written objection. I think that they would want to not use a questionnaire so that the government doesn't have the time to investigate everybody. So that you just off the cuff, like let's just get the jurors based on a feel. And I think that would be opposite to what the prosecutors want in this case. So it'll be curious to see what happens here. Less of a substantive motion. I'm curious to see what Trump's response looks like when we get there. But this is the Chutkan docket, and so we'll see some more activity on this case soon enough. Nothing here in the follow-up to that filing. So when Trump's team responds to this, we'll of course cover it, my friends. Hopefully you're joining us and subscribing and hitting the like button to join us on the next one, and we'll see you there.